Hello and welcome. Last time we spoke about empowerment and some of the benefits we gain from following our consciences and upholding truth and justice. One benefit that was only touched upon lightly was the quality of new friendships with people who also express their courage in standing up to the lies and bullying to which we are always being subjected by our imposter governments and fake crown agents. It brings a great joy to associate and work with others who are always willing to help with their time and knowledge in this vital work of restoring the rule of law and justice for our families and descendants. There exists an exhilarating freedom and confidence that we are behaving honourably, despite the existence of some risks, of course, that we may be subjected to unlawful treatment before our final victory. The truth is, however, that everyone is being subjected to unlawful behaviour every day by our illegitimate political class, who hedge us about with unjustifiable restrictions and rules, imposing unlawful fines, fees and taxes, etc. But only a few have the knowledge and courage to oppose such injustices. Nevertheless, there are numbers of groups who are also pushing back against this malfeasance, which come under such generic headings as common law, freemen of the land, sovereign men and women, and so forth. Today I'll be discussing how these can and do add to the level of confusion in people's minds about how best to combat the current tyranny. That is not to cast any aspersions on these people. They also have awoken to the deceptions and criminality of our so-called elites and are displaying courage by standing up to the impositions of police enforcers and illegitimate courts, by challenging them under various interpretations of common law and ancient feudal rights and conventions, etc. However, as we've already mentioned, such strategies involve risky tactics, such as appearing in these fake courts or arguing the toss with police during a random encounter, who may decide to arbitrarily impose some rule of law, inverted commas, of which we may be unaware. By engaging in such confrontations, we grant a dangerous level of legitimacy to the actions of our oppressors. Let's now discuss this in more detail. These comments are aimed at those who already have some knowledge of Article 61 but may not yet have fully embarked on their journey through swearing the oath to the Constitution via the Committee of Barons and starting the sending of notices to those who may already be engaged in some or one of those groups, which I'll refer to as common law groups, which is not to disparage those who prefer other names, it is only for convenience of expression. Fitzroy Sterling, in his excellent series of lessons available with Carl Liebold on Soundbite University on Facebook or on Voy See Freedom on YouTube, see the link in the comments, specifically in Lesson 11 covers this topic very extensively. This video is just to give an outline of the pitfalls associated with engaging with the legalese system and to refer to such further sources. Firstly, as David Robinson said many times, the problem is that we have no properly constituted public courts of law. We have only courts which operate with what is called the colour of law, that being the 12 presumptions of Roman canon law. These have been built up over time to instill a belief system in the minds of the people, who remain basically uneducated in law, that what we have is legitimate and legal, inverted commas. It also instills in the minds of its practitioners that what they are doing is technically honourable, inverted commas, and therefore will protect them from the karma that inevitably follows when fraud is exposed and criminality punished. Those at the summit of this edifice understand their actions breach every common law right and notions of decency which are apparent to all who possess a conscience. To that extent, the entire legal system can be regarded as a series of superstitions, which, as we all know from experience, can make ostensibly rational people behave irrationally under certain circumstances. Such is commonly observed in religious communities or in populations which are poorly educated in the ways of science, for example. We can see here over 3 A4 pages a document. It lists the 12 presumptions and finishes by challenging any such court to prove beyond doubt that they are not committing treason and personage, a form of human trafficking, in their dealings with people standing under Article 61. These 12 presumptions, asserted by the private bar guild, which if unchallenged stand as true, are public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor/beneficiary, agent and agency, incompetence, and guilt. Because of time constraints, we can't deal with all these in this video. That is done in Fitzroy's 11th lesson. So let's take a few examples and discuss their meanings. Number 1, presumption of public record. This is that any matter brought before a state court is a matter for the public record, when in fact it's presumed by the members of the private bar guild that the matter is a private bar guild matter, unless openly rebuked and rejected by stating clearly the matter is to be on the public record. The matter remains a private bar guild matter, completely under private bar guild rules. Number 2, presumption of public service. This is that all the members of the private bar guild who have all sworn a solemn, secret, absolute oath to their guild then act as public agents of the government or public officials, inverted commas, by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. Number 3, presumption of public oath. This is that all members of the private bar acting in the capacity of public officials who have sworn a solemn public oath remain bound by that oath and therefore bound to serve honestly, impartially and fairly as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under a public oath. This third example accounts for the stories some of us have heard of magistrates or judges being commanded to reveal under which oath they are standing in the matter before the court, and literally running from the room before they are exposed as duplicitous fakes. Because of the superstition that everything must be seen to be honourable, inverted commas, they have no choice but to do so or be censured by their own guild. The remaining 9 presumptions all carry equally duplicitous connotations, and it is a brave and perhaps foolhardy person who willingly steps into such a web of deception, thereby granting a wholly unjustified tint of legitimacy to what is obviously a criminally fraudulent artifice. That there are persons well versed in these matters who successfully negotiate the traps and pitfalls is true, but how long would it take to educate a sufficiently large proportion of the population to be able to replicate such expertise? Even assuming that anywhere near enough people are remotely interested in doing so, given the success of the legalese system in establishing its superstitions in the minds of the general population. We also need to factor in the possibility that people who can write legislation at will might decide at any time to enact something that will nullify the strategies of the common law aficionados. Such a ruse is not available when dealing with constitutional law, and the people have the option of non-compliance as a given. In passing, I refer to my covering letter to Officer Halfname at the TGA. We can see that this officer and their organisation operate under the presumptions of agency, incompetence and guilt, to name just some. The presumption of agency means that under contract law the accused, me, has expressed and granted authority to this alleged Crown agent to act in this matter, which I have expressly rejected by my notices. The presumption of incompetence means that they presume that I am at least ignorant of the law and therefore incompetent to represent myself. This has been rejected by my notices and the covering letter. The presumption of guilt in this case means that should the matter proceed to a court hearing, it would be regarded as a private meeting of the Bar Guild, where I would be regarded as guilty no matter what plea I enter, or even if I enter no plea. This presumption I have rejected by my notices and my covering letter, where I have demanded that they show proof of their jurisdiction over me now that Article 61 is in effect. They have not rebutted or offered substantive evidence for any of their claims, so the matter is now in limbo, until either I receive my stolen goods or act in a tort or commercial lien against the officer involved, which I may do at any time in the future suitable to me. An interesting point is that despite Officer Halfname's claims against me that I have acted unlawfully, the third consignment of my goods did arrive after passing through the Australian Border Force inspection regime, which makes the TGA's actions inconsistent with their words. I don't expect to hear more, but it did take them a couple of months to scramble together a seditious reply while in dishonour to my notices, so we'll wait and see. Thus, we see that it is totally unnecessary to go into these questions about presumptions or Bar Guild rules if we stick to the simple overriding approach of standing under constitutional law. We have nothing to gain from such a risky venture as getting involved in legalistic wrangles with people who are already committed to policies of deception and verbal trickery. A further problem with the common law approach is that by stepping into these fake commercially motivated courts, even if successfully, and by no means are all who do so successful, we contribute to their continued existence and acceptance in the minds of the public. Would it not be infinitely better for these fake establishments to simply be starved of potential victims by an ever-growing number of non-appearances by the intended prey? How long would they survive if 25, 30, 40 or even 50% of those summoned or invited to appear simply cited Article 61 as a challenge to their alleged authority, which they were unable to refute, and thus avoided any risk of trickery or financial punishment? Such a scenario would inevitably snowball into a demolition of what, in common with the Apostle Paul when castigating hypocrisy, we could refer to as a whited wall or sepulchre, meaning a building made to look clean and acceptable externally, but which within houses the corruption, decay and stench of the dead. That is the beauty of Article 61, its simplicity, ease of understanding and breadth of influence. To anyone willing to listen with an open mind, it can be learned in half an hour. A main reason it takes many people much longer to grasp its implications and make use of it is because of the existence of so many conflicting voices about how best to combat the traitors pretending to be our government. Once one does grasp the concept, its ability to repulse any form of unlawful dictatorship, including that attempted by other corporate thugs, such as employers seeking to impose medical crimes on their employees, becomes apparent. There is no need to learn complicated intrigues of legality or to grant even the slightest semblance of legitimacy to criminals and their fraudulent schemes by venturing into their territory and trying to use their own system to beat them. All we need to do is stand in the simple, irrefutable truth of Article 61, so brilliant in conception, so comprehensible to the layman, and thus most equitable of all laws ever written.